I am delighted to be here with you this evening to moderate this roundtable about intellectual property strategic management. Now, first of all, I think that many of you, when you think about intellectual property, you see it as a sword and a shield. The sword because with IP, you basically attack your competitors if they want to exploit your intellectual property. And then as a shield, because in that way you can protect yourself against lawsuits for IP infringement. Another conventional wisdom. IP, I leave it to my lawyer. I don't want to hear about it. It doesn't have anything to do with everyday management. That's a legal issue. Well, exactly by following these two approaches, what you do is that you are missing the opportunity to enjoy all the benefits of a clever intellectual property management, strictly connected to your business. And this is for one reason. Because we all think that intellectual property is nothing else than a fence around our intellectual capital. So why is it so important if it's just a fence? Because it's not just a fence. And why? Let me show you this example. Now, when you register a trademark, when you file a patent, you indeed put a fence around your intellectual capital. But there is a huge difference between a wild land and an intensively cultivated one. Because the first has just aesthetic value, while the second produces value. And this is exactly the difference between owning intellectual property and managing it. Why do we protect with IP our intellectual capital? Well, we do it because in that way we give a legal and monetary value to the intellectual capital itself. And moreover, what they say generally is that by acquiring IP rights, we get freedom of action. This means that we are free to develop our products without being afraid of cheap competitors. And on the other side, we can protect ourselves from future lawsuits for infringement. But how do we create intellectual capital to be patented afterwards? You can play solo, or we can do it with others. I'm talking about what they call joint development agreements. This applies especially to companies coming from different industry sectors, when they don't have enough expertise to develop a single product, they enter into a joint development agreement. What's the final output? They share the R&D cost. They grow together two different IP portfolios, and instead of fighting on how to slice the innovation pie, they grow it up together. And how do they do it? Through cross-licensing, through IP strategic management. Third option, you can license IP from others. Sometimes you're simply forced to do it. When you need exactly that small chip to implement your product, well, you need to license. But some other times you want to license IP from other market sectors. For example, for marketing. You can buy an IP portfolio by buying an entire company, by buying slices of their IP assets, or by merging different companies. So the decision of what to protect is fundamental, both because you're spending money and because from what you're protecting now, it depends what you will do later. Then you need to decide when to protect, where to protect, and how to protect. IP is territorial. It's not that if you get a patent here in Hungary, it's worth and valid anywhere else. So if you don't have clear in your mind what is your market region, what are you targeting, you cannot take any decision about intellectual property. Third, do you want to go out with outsourcing, meaning that you want to give all your IP issues to an external firm, or you prefer to build inside your firm an intellectual property department so that this department shares your business goals, share your vision, and then you put this department working together with your R&D department and your managing board all together. What do you want to do? That's also a strategic decision. You need to generate some value out of IP. The easiest, you exploit in marketplace. You create a product out of your amazing amount of patent. Imagine that someone started infringing your IP. What do? You may license IP. Licensing is one of the most flexible and useful tools in intellectual property. Once you understand it, IP really becomes your core asset value. In intellectual property management, and you understood it already now from all the tremendous amount of questions I already posed, that one size does not fit all. Meaning that every time you're playing with your intellectual property items, you need to understand what you want to do with it. You need to understand what are the external conditions, your market and economic condition, the behaviors of your competitors. You need to understand the behavior of your neighbors. You need to understand what you want to do with your products. What are your possibilities? You need to look forward. You don't just need to run to an IP office. You need to look forward. And what you can do is that you can basically put yourself in any part of the spectrum you can see here. Intellectual property is the perfect marriage between law and business. But this perfect marriage is not an easy one. You already heard about the flexibility you need, the creativity you need to create a real strategy, a successful strategy. But this type of coordination, this type of creativity requires that we talk together, that we put together our different expertise, that we think together what does it mean IP and what do we want to do with IP.
A manuscript, a scientific paper, and a patent is roughly the same thing. They're about 20 pages long. This is professional text. Most of the time it is in English. It has some figures. It has a nice structure. It's roughly the same. But there are some very important differences. And there is only one thing which I would like to highlight is claims. Because in a patent, there are claims. In a research paper, there are no claims whatever. So what are those things which the idea owners, the researchers, the scientists, the people like me must understand? So the protection and the ownership, and Katalin told you about it in a much nicer way, are different. So if you have valuable intellectual property, it doesn't mean that you have valuable protection for it. Recipes cannot be patented. You can have very nice recipes which are really important. It's impossible to patent them. And there are all sorts of other things. Or if you have protected IP, like you have a very nice valid patent, it doesn't really mean that this is valuable at all. There are sometimes very weak patents, or sometimes just the IP costs more than the revenue it generates. When in a startup and we start to talk about patent strategy, it's always the first question, okay, how much money do you have? Because patenting is really a cost item. It's in the cost section. How much money it is just taking away from research, taking away from business development, taking away from going to the market. So always keep this thing in mind. Then the other thing, what is your business model? Because before you even start building your IP strategy, you must decide whether your business model needs it at all. For example, some business models are not heavily dependent on IP. Because if you go to an investor, especially in biotechnology and life sciences, they always ask you, okay, show me your patents. But when you look up the successful companies and their patent portfolios, you may be surprised. Okay, Mercedes has 82,000 patents, and I know that Callaway Golf has more than 600 patents on golf clubs only. But there are other companies who don't have any patents, like Red Bull. Red Bull is one of the biggest innovations in life sciences and a huge moneymaker. It's a true innovation. It works, generates money, and the recipe is on the label. So there is zero protection for it. So their business model is very nice, but it is not dependent on IP protection. It's dependent on the IP, but not the protection of it. You also have to decide whether you plan to sell your IP as a valued asset, or do you plan to sell the company with your IP as a valuable asset. That's always very important, especially in life sciences, when you sometimes start a company and sell it before going to market. Like if you're developing a drug, there is a very nice exit point after a clinical study, phase 2. But then after phase 2, you're still very far away from market. So what you really have is a bunch of documents. You have maybe 1 or 2 patents, this thick, and maybe or probably a dossier from phase 2, which is about this thick. That's it. Or do you plan to use your IP for attacking others? I have never seen a startup company who could seriously attack anybody else with their IP or against their IP. Researchers and businessmen talk or use patents a completely different way. And this is so different that this alone can kill a startup company. And if you are thinking of starting a business based on a research result or based on a scientific IP, you always have to think that you are talking about the same thing, but you are thinking different ways.
We have different layers in our IP strategy, and for a small to medium enterprise such as ourselves, we do have a couple of patents, but they do have their setbacks for a company like ours. You need to be a large capital-intensive company in order to really support legal IP protection. There's a lot of costs involved. As soon as you publish an IP, and as soon as you publish a patent, it calls attention to itself. There's something worth protecting. There's something valuable there. So the second layer of our IP protection is really in the complexity of our technology. Okay, and this is really a key part. And so up on top you have the patents and the utility models, but really getting down to the meat of our strategy, you've got our know-how and the software and the algorithms behind the software that we use to do the basic, design of our treatment plants. And what's behind this GUI, this graphic user interface, are the secrets and all these algorithms. So our engineers inside our company can actually be using this graphic user interface without knowing these secrets. They can size a wastewater treatment plant very accurately, very effectively, without even knowing the mathematical secrets behind it. These are people inside our company. We don't build treatment plants all over the world. We can't do it. We can't learn 500 different languages, 500 different regulatory landscapes. So we rely on partners to bring our product to their markets. Counterintuitively, partnerships can be an effective IP strategy. So again, our philosophy is very much an open one. We like the idea of sharing knowledge. We think we have something good in our hands that is very difficult to replicate, so we're not that concerned about it.
When we talk about business software, which by this I mean all the Microsoft products you use and lots of other products you use in the businesses, this used to be a very important factor when the companies, quite high-profile companies, were analyzed for legal risks. Today in Hungary, more than 90% of the companies over the 500 employee threshold are legalized. So we can say that in this area there was a quite big breakthrough compared to the late 90s, where this rate was around 20–30% in that particular bracket. When you talk about the middle-sized companies today in Hungary, this is where the real battle is waging, because these companies are the targets of the Business Software Alliance's program. When we talk about the really small companies, which means less than 50 employees, this is a very difficult area. It is quite close to the households. The general average number is 34% for Hungary for all business software. I'm talking about illegality. When we come to entertainment software, I think this is an unwinnable war. Even the large entertainment software companies such as Electronic Arts, or I can name a few, they actually are very shy about this war. So they don't want to force, by the means of law, the users to legalize. So they don't want to have this PR exposure whereby they are actually having the police drag the kids from the PCs for copyright infringement. And the last on software, this is the EU software area. I don't know how many of you have heard about the EU software, which is a very cheap and good alternative to buying brand new licenses. In Hungary, from January 1st, we have a new authority on data protection. And finally, the authority has the right to fine companies who are not compliant with the Hungarian data protection regulation. This is the good story or the good news, but on the other hand, the data protection regulation in Hungary and also in Europe in general is very rigorous, and sometimes it is the only major obstacle in the way of having more and more research in this field. As opposed to the United States, for example, where data protection regulation is looser, and China, where there is basically no data protection. And I think everybody should give a second thought then when he or she is very happy about data protection. Sometimes the clients totally misunderstand the concept of copyright protection. Software copyright protection only protects the form and not the content itself. So that's a very important point to make, and a very big misunderstanding. Trademark, it is also very commonplace that the clients completely forget about the trademark protection, which is in a way a useful protection for an idea, for a name, for a thing that the client wants to protect.
I'm sure that you have heard a lot about Disney. And actually, the extension of copyright protection is according to several articles, attributable to the fact that the Disney copyright was about to elapse. So in the US now, original copyright protection of 50 years after the death is increased to 90 years, whereas in Europe it's increased to 70 years, but there are discussions that it should be extended also to the US minimum. In every case, when we have, for example, a film production in Hungary, we have very good tax incentives. But one of the reasons why we have so less film production actually going on in Hungary relies on this issue. In Hungary and in whole Europe, it's impossible to grant license for future forms of use, for example. And this is such a huge area uncovered, which means that you should have a contract governed by not Hungarian law, and there are very many Hungarian production companies who rather not sign the contract and walk away because they're afraid of the other issues. Open versus closed approach here. Innovative pharma, they're very closed in their approach. Generics, they're very open because they are the attackers, so they would like to share their new innovation. How to manage your IP at the company. Your own IP. Review labor contracts and have employee invention regulations. In Hungary, there's a difference between service invention and employee invention. In the rest of the world, there is none. Please regulate how your employees' inventions become yours. That's the key. In Europe, there is a block exemption regulation, which a renewed one, which entered into force in January 2011. And will be in place until 2022, where not only joint projects, but actually also funding of R&D can be exempted. If both parties and the aggregate market share is below 25%, that's a big hurdle to make use of the block exemption. But if you're an innovator, if you're a new company, you should make use of that when identifying your partner.
Can you protect intellectual property using an open innovation model the way P&G seems to have done? Or is this a kind of oxymoron?
There is something called a process called generativity, described by Jonathan Zittrain in the United States, referring particularly to Apple and the application store. So what they do is that they leave open a certain part of their software portfolio, and they let customers interact with it, develop particular application, but then they are forced to put that particular application on the Apple Store, and they can just sell it through that channel. So they basically enter already into a license agreement, which is a kind of bounded to the fact that afterwards Apple will get the revenue out, part of the revenue out of the selling of the application. This is because intellectual property can be used, but just in particular sectors. It's a kind of rigid instrument. So what you use to go around this rigid instrument is all what is the contracting, the so-called contracting around. So that's why when we discuss about intellectual property strategy, we don't have just to focus on the classical patent, copyright, trademark, but we always need to think about the fact that we should be creative, we can be creative, and the wonderful thing is that we can discuss with attorneys, we can discuss with the management, we can discuss with developers, and together we can figure out what we can do. And for sure, Procter & Gamble did something like this.
For some topics, it's almost impossible to find IP attorneys who can give you a very good judgment whether your patent submission will be valid or how to put together the claims, because these topics are so special that there are maybe a handful of experts around the world, and they don't happen to be in Hungary. And I was lucky enough to have some patents which was written in Hungary, and I could sell it internationally. But in some other cases, you just have to go right to the United States or to Germany or to the Far East to have the kind of people who can really formulate that patent submission up front. So in some cases, the 70% of the money which is in the startup company goes to the patent attorneys, because we definitely need the best ones, otherwise we are worth nothing. And that's a drawback. But I think it's a drawback in every location which is not a big innovation hub. I think it's the same in the US Midwest as well.
Technology and development is always a couple of steps before regulation. That means that we are at least in 2 to 3 years in arrears with any technological innovation that is available. So what we always suggest under those circumstances is actually use your common sense and try to find the best fitting, the closest currently existing rule, and abide by that. And then you are the closest possible in your protection.
I think this was as sophisticated as anything I've ever seen in this topic. It was both breadth and depth, and local and global and regional, and covered different sectors. And I think I've never seen a discussion on such a complex, important topic done in a couple hours as well as was done here. Katerina, thank you for putting it all together. Terrific introduction and a terrific presentation by all the panelists. I think we really have to give them a round of applause.